Well, good afternoon and welcome to this week's presentation by the Estate Planning and Probate Group at Beresford Booth. My name is Per Oscarsson. I'm a member of the group. And with me today is Sarah Smith, also a member of our Estate Planning and Probate Group. And our topic today is estate planning and real estate, houses, vacation properties, and investment properties. What we're going to talk about a little bit today, and we'll probably just do it as more of a conversation, is some of the vehicles that are available, not in each situation, and we'll get to that, but some of the vehicles that are available for estate planning involving real estate. The other, I think one of the other more important aspects is what's the purpose of the estate planning, and we'll get into that because the purpose will also help to determine, which vehicle is best in your particular situation. So we'll start with the vehicles. I think of them, several of them. A deed during life, that of course takes the property out of your hands completely, but that may be your intent. Another thing is putting the property into a limited liability company, and we'll get into that as well a little bit. Transferring a property under a will, which means that the transfer does not occur until after death. Property could be transferred by way of a trust. That could be a trust that is created during your lifetime, puts the property into the trust. You may benefit from it at that time. You may not. It could also be a trust that is established under the terms of a will. You could also have, I guess more so in the trust established during lifetime. It could be a revocable trust, or it could be an irrevocable trust, and we'll talk a little bit about that as well. Another option is a joint tenancy with right of survivorship. That transfers at least part of your interest in the property to someone else, but you still retain some interest. And then there's also a relatively new idea, which is the transfer on death deed, and we'll talk a little bit more about that as well. So with the vehicles, as I mentioned, we said a deed during life. Typically, that would be a gift. It could be a sale to a family member. It could also be a deed, maybe to a charitable organization. Maybe you're gifting in that respect. But the transfer, regardless of what of the vehicles that I mentioned, the transfer actually takes place by way of deed. That's going to be required in order to transfer the real estate. Again, limited liability companies, often those are used for investment properties, and it provides some limited liability. It protects you in the event, for example, let's say an investment property of an apartment building or some other kind of commercial building where maybe there's a lot of traffic, pedestrian traffic, and someone gets injured. They will typically sue the owner of the property. Best to have it in something like a limited liability company where the limited liability company or the LLC would likely be sued, but you as a member, or maybe even the only member of the LLC, may be able to avoid being sued because the property is held by that LLC. There are other aspects to it. Has the LLC properly insured the property? Have you kept your other business, whether it be personal or other businesses, separate from the LLC, so that there's no confusion over who actually owns it and how it's actually used? A will is also a way that, again, just acting upon death, that you could transfer property. And it could be transferred in any number of ways under a will. For trusts, I'm going to turn it over to Sarah to talk a little bit about some of the considerations that might occur in determining whether you want to put property into a trust. Sarah?
So while we're talking about vehicles, trust as a vehicle works by essentially transferring ownership immediately, assuming we're talking about a living trust, which often is the case with estate planning, or upon death, if we're looking at a testamentary trust. But the idea is that it's used to transfer the ownership the way a deed or some other document would. And when we're looking at whether we're using the LLC, we're thinking about asset protection, maybe we're doing a deed during life, we're trying to do some lifetime gifting, perhaps for tax purposes, perhaps out of the goodness of your heart. And trusts are a really great tool because they can be used for pretty much all of these purposes, depending on what your goals are and how the trust itself is structured. So a living trust is what I'm going to focus on for now, is a trust that you create while you're alive. Very often you'll see revocable living trusts is something that you might have heard before or heard us talk about before. These are the kinds of trusts where you can maintain the ability to change or revoke them entirely. It gives you a great deal of flexibility. This doesn't get it outside of your estate for tax planning, but may have tax planning measures built into it upon your death, and will typically avoid probate if it has been properly funded, because we have then funded the trust and transferred the assets prior to death, and we don't need to utilize the probate process to transfer those assets later. This can make things easier on your estate. Now, Washington, as you've heard us say before, pretty effective, time efficient, cost efficient. Between the cost and administrative hassle of trusts versus the cost and administration required of probate, I won't typically recommend a trust solely for probate avoidance. But if you, for example, have real estate in multiple different states, whether it's personal, commercial, or what have you, each of those different states where you own real property will require its own probate if it's opened by an individual, the individual decedent, not the LLC, not the trust, but the individual. While one probate in Washington, might be very cost effective, but 3 probates in Washington, California, and Arizona, probably not so much. This is where we might look at a trust, not for tax planning purposes, but for that probate's avoidance, to transfer the real estate now, not upon death. Conversely, if you have a great deal of real estate and this creates a tax problem, a success problem for you, we might be looking at drafting testamentary trusts, which have tax planning built into them, whether it's a disclaimer trust or a mandatory trust to make sure we're utilizing exemptions available to the decedent, or even just creating trusts so that we're exerting more control. There's a property that's being enjoyed by multiple members in the family, and we want them to continue to enjoy that vacation property or family home or business property for many more years to come. But we don't want 3, 4, 5, 8 people on one deed as joint owners who are all going to fight about how the property is to be managed and what's going to be done, and someone gets into debt and suddenly that's somebody has an interest in the property that's not your intended beneficiary. We'll circumvent that entire thing, and maybe we create a trust for that real property with instructions about how that property is to be managed, how the beneficiaries are to enjoy it or not to enjoy it, what happens to the property after X period of time. There's a lot of flexibility that we can utilize to draft to achieve your goals by utilizing something like a trust. Per made that excellent comment earlier about LLCs providing liability protection, which is something that can be incredibly helpful. If, as you say, somebody gets sued, the LLC, those assets then become at risk versus all of the assets you hold individually. A trust, depending on how it's drafted, may or may not offer those types of protections. Especially a trust that you create for yourself is really not going to provide the kind of protection that an LLC can from those types of things. So we really want to be goal-focused and goal-oriented when we're discussing which tool to use. probate avoidance, a trust is going to make a lot of sense, or perhaps a transfer on death deed if it's an option. If it's a commercial property where there's a functional business of some kind, a lot of traffic, as Tara was saying, an LLC is going to make a lot of sense. It really just depends on what the goals are at the time. And when we're talking about tax planning, that can be done with a trust-based plan, that can be done with a will-based plan, that can be done with lifetime gifting. There's just a ton of options available, as long as we come from this from a perspective of what do we want to get done. And then I think we still have to talk about transfer on death deeds. Yes, is that what we haven't covered?
Yep, transfer on death deeds and a joint tenancy with right of survivorship. I'll start with that one. That one, I don't think we see an awful lot of those. They're pretty easy to create. It normally means that you are retaining some ownership during your lifetime, but that's another one of these where if the property is held, and it could apply to real estate, it could also apply to personal property. I think it's probably even less likely to be seen in personal property, but it could be. But when you've got real property or real estate, it's a non-probate form of ownership. That is that if a will does have to be probated, it's not typically going to include joint tenancy with right of survivorship property, because that property by operation of law transfers because of the form of the deed that was used to create that form of ownership. So for example, if you have two owners as joint owners with right of survivorship, upon the death of the first, the second owner becomes the owner of all of it.
As opposed to tenants in common, correct?
I'm sorry?
As opposed to tenants in common.
As opposed to tenants in common, where there's not an automatic transfer. And by the way, also with community property, there's not an automatic transfer to the surviving spouse, because each spouse could convey their half interest to one or more individuals that they would like to benefit. Mm-hmm. But with a joint tenancy with right of survivorship, it just automatically transfers with no additional deed having to be recorded. So then we get to transfer on death deeds, which are a relatively new vehicle available in the state of Washington. I think we've only had it for about 7 or 8 years. This is a deed that is recorded during your lifetime. In fact, has to be recorded prior to the transferor's death in order, one of the things, to be effective. It's revocable by the intended transferor. It looks a little different than a typical deed because it also has to specifically provide that the transfer is to occur on the transferor's death, that being the person who is granting the interest in the property. The form of deed may vary because there are a number of different types of forms, like a warranty deed or a bargain and sale deed or a quitclaim deed. Another thing with transfer on death deeds is, although a warranty deed is the strongest deed you can have, and a bargain and sale deed has a few less warranties of title that protect the recipient of that title, a transfer on death deed does not contain any covenants or warranties as to title in and of itself. And I've always thought it's a little unusual that the state law says that even if all these warranties are specifically included in the will or in the transfer on death deed, they aren't there. The law says that there is no covenant or warranty of title with the transfer on death deed. Another thing that's a little bit different with these deeds, typically with a deed, there has to be what's known as delivery of the deed. Sometimes that has been as simple as, well, it got recorded, so it must have been delivered to so the beneficiary knows about it. With a transfer on death deed, the beneficiary does not even need to know or have accepted the deed. They don't even have to have noticed that there is such a thing out there. And they may not even know until after the granting or transferor party has died that there is such a deed out there. Uh, there's I think, a great deal of flexibility with the transfer on death deed because of the fact that during the transferor's life, it doesn't affect any interest or right that they or any other owner of the property has in the property, including the right to transfer the property to someone else or encumber it by mortgage or deed of trust loan. It also does not affect any interest or right of the transferee, the recipient of the property, even if they know that that deed has been recorded. It does not affect any interest or right that an unsecured creditor or a secured creditor of the transferor party has. So if there's already a mortgage loan on that property, for example, it's not affected by the fact that there is a transfer on death deed, because until the death of the transferor, there has been no transfer of the title. It also does not create any kind of an interest, legal or equitable interest, in the recipient of the property prior to the transferor's death. So, for example, they would not be able, I think, in just about any case, to use that property for any purpose, such as security for a loan, because they don't have a legal or equitable interest in the property until the death of the transferor. And until the property actually transfers to the recipient, there's no right of a creditor of the recipient to make any kind of a claim against the property. So those are some of the things about these. And again, you could revoke them at any time. There are some ways to do that, but that, I think, can be quite a benefit. It would still be considered part of the estate for purposes of determining, are there estate taxes that are due and payable as a result of the transferor's death. But again, the transfer and death deed is a non-probate asset, so it does not become part of a probate asset, or does not become part of a probate if a probate is necessary. And regardless of the vehicle that's used, like, we talked about LLCs, trusts, wills, the mechanics are going to be the same. There's going to be a deed involved because Washington law says to convey an interest in a real property, it must be by deed, and there are certain requirements of deeds. Sarah hit on some of the purposes that we would have and would discuss with the client about why do you want to transfer the property and when do you want to transfer the property? For example, is this a gift? Is it for asset protection purposes? My example of the apartment building. Keeping the property in the family, and what may or may not be related to that, management of the property. One thing may be, I'd like my family to benefit from this, but I don't want all of them to have to deal with it. Or I may believe that they're not capable of dealing with it, and so I want to set something up where maybe one of them is, and whether that's an LLC that's only owned by family members, and maybe one of the members is the manager. Or it may be a trust where there is potentially a family member who is the trustee, or potentially some third party who may be known to the family, or maybe it's a professional trustee that deals with the management issues related to the property. As Sarah said, another thing is estate taxes. You may be wanting to change the ownership of the property, get it out of your estate, which typically would mean putting it into an LLC, putting it into an irrevocable trust, because at that point, that property, although you may still have some sort of an interest in it, is not your property for purposes of estate tax calculations. Now, having said that, there may be federal gift tax implications in having put that property either into the irrevocable trust or having gifted it directly to someone or multiple people. And those are things that need to be considered at the time that you're planning, what do I want to do with this property, if anything. I think the simplest is the will, where I just want to gift my property to whomever I want upon my death, but I'm not really, maybe I'm not concerned about estate taxes. I'm not concerned about, do they have the ability to manage? I would just like them to have it outright, and they can, maybe they really don't want it. They'll take it and they sell it potentially. But again, that could be something that you, as the person now owning the property, could probably control by whether you create an LLC and provide some things in there. You know, it can't be sold for 10 years, 5 years, or a trust that leaves it up, maybe leaves it up to the trustee to determine. But I think all of those things are considerations to be made when you are thinking about what you want to do with your real estate.
And while we're considering those things and talking about taxes in particular, retitling a real estate or another asset in and of itself is often not enough to get it out of the estate. When we're talking about creating trusts or actually, let me rephrase that. It sounds very simple to say we're going to retitle something or set up an LLC or set up a trust. And it sounds simple, but in practice, there are administrative requirements, there are fees associated, not just in the establishment of these entities, but also in the ongoing maintenance annually, whether it's filing tax returns, keeping accounting, LLC agreements, the sorts of things that go into making sure that these entities are properly funded, properly run, and properly documented throughout the entirety of their existence. And that's also something that you want to be sure you consider. Is either the tax savings or the management or whatever goal it is you're trying to achieve going to be worth that investment from you and or whomever your the other members or future trustees or what have you are going to be required to put in?
That's a good point. What we typically think of, I think, is more so, I think, with trusts than with other things, particularly if you have a professional trustee involved. They typically have a whole schedule of fees. And there will be the need, particularly with irrevocable trusts, I think, to do an income tax return. So there may have to be an accountant involved. Because I don't think for most people trying to prepare a trust income tax return, given what I have heard about most people thinking, doing my own tax return, I mean, it's not fun, but I think it becomes less fun if you're doing a trust tax return. And there you're going to probably need to have some professional assistance by way of a CPA to help prepare that and help you understand what kind of information do you need to be keeping track of in order to allow them to better serve you in preparing a tax return. So that's all I have. Sarah, did we have any questions from anyone?
I'm not seeing any so far. Hopefully that means that we have been thorough and clear.
Right. So with that, I will say thank you for joining us. Next week, I believe our family law group will be presenting the webinar on Thursday the 19th. So again, thank you. Enjoy the rest of your day.